Hello everyone, in this video we are going to see about what is mean by arbitration agreement. So before I proceed with the normal theory part, let us see how the draft will look, how the agreement will look. See here there will be clauses like a subject matter of disputes, the number of arbitrators and the seat of arbitration. The seat of arbitration means the place of arbitration where which the proceedings will take place. So with this seeing the draft, let's proceed with the theory part. So first let's move on to the introduction part. Here what they're saying means, see, arbitration agreement is a formal agreement, okay. Here where the parties will decide to resolve their disputes through arbitration rather than going for the court. Then usually this agreement will be in the written format. Then it will contain the clauses regarding the subject matter of disputes, the number of arbitrators and the seat of arbitration. So let's see the definition. See, as per section 2 clause 1b of the Arbitration and Conciliation Act 1966, it simply provides that arbitration agreement as an agreement referred to in section 7 of the act. So we have to see the section 7. We have to refer the section 7 to understand what is meant by the arbitration agreement. So accordingly, section 7 of the act provides that arbitration agreement is an agreement by the parties to submit the arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legalship, whether contractual or not. See, here what they are trying to say is it's an agreement by the parties. Here they will submit what the agreement will state means submit to an arbitration with respect to all or certain dispute. You can submit the entire dispute them, or you can submit a certain dispute to them, okay, and which may have risen, like it's already have been risen, or which may going to rise, okay. So between them in respect of a defined legal relationship, that should be the legal relationship between the parties. So it may be contractual or not. Next comes forms of arbitration agreement. As per section 7 clause 2, here what they are trying to say is there can be two forms of arbitration agreement. First one is clause in a contract. Here the arbitration agreement can be in a clause within a border contract. There will be on main contract. In that there will be the single clause will be mentioning about the arbitration. Then comes separate agreement. In this video I have showed you the separate agreement, how it looks. Here alternatively it can exist as an independent agreement. Then comes written form requirement. As per section 7 of the act, an arbitration agreement must be in writing, which can be satisfied through. So the main arbitration agreement can never be the oral, it should be in written, okay. Then how can be, it means a document signed by the parties. It can be signed by the parties. Then comes exchange of communication, including letters, fax, telegrams or electronic communication that record the agreement, okay. Then exchange of pleadings. Here statement of claims and defense where the agreement exists is alleged by one party and not denied by the other. Here what they are trying to say in the third point is, for example, there was the agreement and the party have filed the statement of claim, okay, but other party doesn't reply to that. So there will be perception that the existence of the agreement. Then comes a reference in a contract to a document containing an arbitration clause also consists of written arbitration agreement if the contract is in writing and reference incorporates the arbitration clause as part of the contract. See, it is simple. There will be the clause mentioning that with respect to the schedule 4, like they will refer something in the contract itself that also forms as a arbitration agreement. So what are the key features of the arbitration agreement? This was dealt in the KM Modi vs. KN Modi in the year 1998 by the Supreme Court of India. Here what they have said means they have elaborated the essential features of arbitration agreement. First is arbitration agreement must indicate that arbitral tribunal decision will be binding on the parties. It should be the stating that we will bind by the arbitration decision or arbitration award. Then comes the arbitrational jurisdiction is based on the parties' consent. Here you can decide the place of the proceedings, okay, seat of the venue, okay, and legal provision. Then comes the tribunal will determine the parties' substantive rights which must be outlined in the agreement. See, in the agreement itself, they have to outline what the tribunal will have the power to determine the party's substantive rights. Then the tribunal must ensure fair and impartial determination of rights. There should be partial. There should not be the partiality, or there should not be unfair to the other parties. Then the agreement should ensure that arbitral tribunal is legally enforceable, in the sense that it should not be opposed by the public policy or morality, or opposed by the any other law for the time being enforced. Then the agreement should specify that the tribunal scope is limited to the dispute identified at the time of the reference to the arbitration. Here the agreement should state that what is the scope of the tribunal while deciding the matter. So these are the key features that have decided in K.N. Modi versus K.N. Modi in the year 1998. Then, so conclusion states that, see, the main question regarding reference to the arbitration and arbitrarily completely depends upon the existence of the arbitration agreement. It is the basic one. Okay, without this arbitration agreement, we can't refer the dispute to the tribunal or arbitrator. So not up, and here not upon the whether it is a civil dispute or a commercial dispute. Therefore, the arbitration agreement marks the first step of the arbitration process. So I hope you understand what is meant by arbitration agreement. Thank you.